Good morning and welcome. My name is Zia Bhaloo and I'm joined by my colleagues Camilla Lamont, David Nicholls and Evie Barden today. We're delighted to see so many of you joining us today. I can see the participants are still going up. We're expecting about 348. I say expecting, the weather might put paid to that. But thank you for coming. As you know, we're going to be looking at CVAs and restructuring plans, and the focus is going to be on three relatively recent decisions that I know many of you are familiar with, some of you very familiar with, having been in them. If I may, I'll just pick up a few housekeeping points. Your microphones are automatically muted, so you won't need to adjust your local settings. You're very welcome to submit questions via text in the Q&A button, which is either at the top or the bottom of your screen. We will do our very best to answer some of the questions, but that will be at the end of the presentations because there's an awful lot to cover, and presentations will likely last a full hour. So if you do want a question answered, if you stay on at the end, we have 15 minutes or so where we'll stay on to chat through anything you'd like to at that point. The webinar will be recorded and you'll receive a link to both the slides and the recording after we finish. And if your connection is lost at any point, you can rejoin by clicking on the original link. As I've said, the speakers today are Camilla Lamont, David Nicholls and Evie Barden. I'll pick up with a few points at the end if there's time. There isn't time for full introductions, but for those of you who don't know us, all of us started in practice in other chambers with a broader commercial chancery practice, including a good deal of property insolvency. That broader range has continued in our practices here, and all of us have advised on CVAs and property related insolvency. Indeed, Camilla was instructed in the Debenham CVA. The structure of the next hour or so is that David will deal with New Look first, Evie will then look at Regis, and Camilla will finish off with Virgin Active. If there's time, I'll pick up with a few of my own observations at the end. And then, as I've said, if anyone would like to stay on for questions, you're very welcome to do so. So I will hand over to David now, if I may.
Good morning. Good morning, everybody, and thank you for participating in today's seminar in relation to recent restructuring decisions. I'm going to spend 50 minutes or so talking about the decision of Mr. Justice Zaccaroli in the case of Lazari Properties 2 and New Look Retailers, which was decided last month. I want to begin by considering some of the reactions and comments in relation to the case, and some of the headlines I've picked up from the press are there on the screen now. A bruising outcome, a pragmatic response, tips the balance further in favour of retailers, deepens tensions between tenants and landlords, inevitable. These are pretty fierce reactions, and they come in the context of a long-running dispute between retailers and landlords, which has generally seen landlords coming off worse, much to their understandable frustration. The New Look case was a significant battle in that war because the challenge by landlords was fundamental. It was described as a root and branch attack on CVAs by landlords, and the arguments went to the very heart of the nature and process of a CVA. But that challenge failed, hence the negative reactions from landlords about the position they find themselves in. And this talk will consider the circumstances in which the case occurred, the arguments set out by the landlords, the reasoning of the judge in rejecting those arguments, and it will offer some glimmer of hope for the future, a glimmer of hope that is from the landlord's perspective. So the circumstances in which the CVA was proposed, well, these are difficult times. The pandemic has caused many issues for commercial landlords, with two problems in particular. National and local lockdowns have caused retailers to say shut up for a long period of time. Tills aren't ringing, customers not spending, no income, no cash to pay the rent. So the first problem has been a huge fall in the amount of rent that retail tenants have been able to pay, and there has been genuine hardship. And that's been exacerbated by the second problem for landlords, the restrictions introduced by the Coronavirus Act, preventing the landlords from taking enforcement action. And whether those restrictions will achieve their objective of keeping the pre-pandemic balance remains to be seen once they begin to be lifted later this year. Now, New Look is yet another retailer that has suffered, both from the pandemic that I've mentioned, but also from the general decline in the high street. It operated from over 400 stores in the UK, employed over 10,000 people. By March last year, its sales were down 32% on the previous year. By late March, it had no revenue, and it went into CVA in August last year. And by that time, it had only enough cash to last a month and was facing imminent insolvency. So broadly, the CVA provided for the vast majority of landlords to have their rent arrears claims compromised, as well as their entitlements to future rent, being left with only turnover rent, that is rent based on a percentage of the turnover. They also had their rent arrears written off, and the CVA was approved by over 80% in value of creditors attending, and nearly 90% of landlords participated in the vote. So a little more about the detail of the CVA. It was part of a package of other measures, including extensions to the terms of loans and a scheme of arrangement. A key feature of the CVA was that it would allow the company to switch to turnover-based rents at 402 of its UK stores, with the remaining 68 branches not being charged rent at all. And in relation to New Look's creditors, there were 5 different categories of creditors. Now, for today's purposes, we can discount the first 2 categories: the note holders whose rights were not compromised by the CVA, and the ordinary unsecured creditors whose rights were also largely unaffected. So this left the category A, B, and C creditors. Now, the category A creditors were the landlords of the company's distribution centre in Newcastle under Lyme. These premises were considered critical to the company's continued operation, and so their position was also largely unaffected. The focus was on the compromised landlords, the B and C landlords. Category B landlords were the landlords of retail premises where the property costs were considered to be above market value, or where a move to a turnover rent was considered critical for assisting cash flow and making the stores viable in light of the pandemic. In relation to these landlords, the category B landlords, all claims for rent arrears were released in full, and the company's obligation to pay rent was replaced with an obligation to pay turnover rent based on a fixed percentage of net sales during a specified period. The landlords were given the right to terminate their leases by notice on or before an initial break date. They had further rights to terminate in each of the following 3 years, and the company also had the right to terminate those leases. The category C landlords were the landlords of stores with no prospect of being returned to viability, and either they had already been vacated or they would shortly be vacated because the business was significantly underperforming. The right to rent and service charges would cease after 2 months, and the arrears of rent were compromised in full. And again, there was a right to both the company and the landlords to terminate the leases on notice. Now, as I've mentioned, the judge described the landlord's case as a root and branch attack on the use of CVAs, and the arguments were formidable. There was a challenge made on jurisdictional grounds, the argument being that the CVA was not a true CVA. There was an argument on the ground of unfair prejudice. The landlords were particularly concerned with the switch to a turnover-based system of rent. They said this was unfair, and it fundamentally rewrote the lease in a matter they said that was impermissible. There was also a challenge based on material irregularities. And at the heart of these challenges were 2 contentions. First, it was said that a CVA cannot be used to effect 2 or more deals on substantively different terms with different groups of creditors, either because there is no jurisdiction to do so, or because it is inherently unfairly prejudicial. Secondly, even if this can be done, it is inherently unfairly prejudicial for a CVA to compromise the claims of some creditors where the statutory majority can only be achieved by the votes of those creditors whose claims are not impaired. Now, the argument on jurisdiction was based on the assertion that the CVA involved separate arrangements on fundamentally different terms for different groups of creditors. It was said it wasn't a true arrangement because it did not involve any sufficient give and take between the parties. And it was said that the CVA improperly sought to interfere with the property rights of landlords. In relation to unfair prejudice, the landlords argued that the CVA was inherently unfair because it was achieved by using the votes of unimpaired creditors to bind those creditors who were impaired. And the landlords also complained that different creditors were treated differently and that various lease modifications were unfair, such as the move to turnover rents. And in relation to material irregularity, the landlords complained about there having been insufficient information about the restructuring disclosed to creditors and about landlord votes being discounted. All three grounds were rejected by the judge. In relation to the first ground, the judge held that the different treatment of different subgroups of creditors was not a reason that supported the jurisdiction challenge or made the CV necessarily unfairly prejudicial. The judge considered that there was sufficient give and take so as to constitute the CVA compromise, because the compromised landlords were in just as good a position as they would have been in had the company gone into liquidation. The new termination rights were part of the package of new rights granted, and these rights counterbalanced the new reduced rent. The judge rejected the argument that the release of all liability to pay rent and other sums under the Category C leases had the effect of operating as a surrender, such that there was no interference with the landlord's proprietary rights under the CBA, noting that it was not an essential requirement of a lease that a tenant should pay rent, and the CVA did not require the landlords to agree a surrender. The challenge based on material irregularity was also rejected. The application of a 25% discount to the claims of all landlords for voting purposes had not been a material irregularity. Based on the evidence about the prospects of reletting and likely rent achievable, a discount of 25% was permissible. This was consistent with the duty to place a minimum value on the claim and did not involve any double counting. Also, nothing had been omitted in terms of disclosure, which would have made a material difference to the way in which the creditors would have considered and assessed the terms of the proposed CVA, such as to meet the threshold required for immaterial irregularity on that basis. In relation to the question of unfair prejudice, the court considered that it must take into account all the circumstances of the case. It will also have regard to the horizontal and vertical comparators. The vertical comparator is the minimum that a return in a CVA achieves when compared with the creditor's position in the event that the CVA is not achieved. That might be the return in a liquidation or administration. The horizontal comparator is the position between creditors, and both comparators must be considered. The mere fact of different treatment between different classes of creditors is not sufficient to establish unfair prejudice, and the court should consider any unfairness caused by the terms of the CVA, the explanation for any differential treatment, and of course all the circumstances, including the alternative proposals. The judge restated the position that it is not necessarily unfairly prejudicial to a subgroup of compromised creditors that the statutory majority is achieved by the votes of unimpaired creditors or those who receive substantially different treatment, although this will be a highly relevant factor. And the other arguments about unfair prejudice were also unsuccessful. It was not inherently unfair to the landlords to reduce future rent while permitting the tenant to remain in possession, but a permanent or long-term reduction in rent imposed on landlords without the option to terminate would be inherently unfairly prejudicial, certainly if achieved by the votes of other creditors who did not suffer the same treatment. The modifications to the leases were not unfair There was no objective criteria by which it could be assessed whether the modifications were unfair in themselves, and crucially, there was no test laid down that the modifications must interfere with the landlord's rights only to the minimum extent necessary to achieve the objectives of the CVA. The fact that the landlords had the right to terminate the leases was significant and answered the point that the terms offered to the landlords were as beneficial as in the relevant vertical comparator. So for all these reasons, the landlord's challenge failed. There may be some hope for landlords. Although the argument of unfair prejudice was rejected, the judge held that where a subgroup of creditors is compromised by a CVA and their vote is swamped at the creditors' meeting by the votes of those who were unimpaired by the CVA, then it is not enough to avoid a finding of unfair prejudice to show that the differential treatment of others was objectively justified and the compromised creditors were treated more favourably than they would have been in the relevant vertical comparator. In certain circumstances, this differential treatment might amount to an unfairness, and the court set out 4 factors to be considered. These were whether there is a fair allocation of the available assets in the CVA between the compromised creditors and other subgroups of creditors. This involves taking into account the source of the assets and whether they could have been available in some other insolvency process. Secondly, there is the nature and extent of the different treatment, the justification for that treatment, and its impact on the outcome of the meeting. There would be strong grounds to conclude it was unfairly prejudicial where a CVA is achieved only because of the votes of a large swathe of creditors who are unaffected by the CVA, even if there was an objective justification for those creditors being unaffected by the CVA. Thirdly, having regard to the extent to which others in the same position as the objecting creditors approve the CVA. And fourthly, a finding of unfair prejudice ought not to be precluded merely because the same result might have been achieved in a Part 26A restructuring plan. However, the judge did observe that there would be strong grounds to conclude that it would be unfairly prejudicial if a CVA compromising the claims of a subgroup of creditors is achieved only because of the votes of a large swathe of creditors who are unaffected by the CVA, even if there was an objective justification for those creditors being unaffected. And this sends out a clear message for the future that there may be scope to challenge such a CVA on such a basis in the future. For many in the industry, the decision in New Look came as a bitter blow. There are 2 particular concerns for landlords. First, the root and branch attack failed. The jurisdictional challenge failed. So a consequence of the decision is that the use of a CVA as a restructuring tool is retained by landlords, is retained leaving landlords with the consequence of having to shoulder the additional financial burden of retail failures going forward, even described by some as affecting an unintended transfer of wealth from landlords and property owners to a business's shareholders, which may have dire consequences for the economy more generally. Perhaps it will be death by 1,000 cuts. The other concern is that the court has permitted the CVA to proceed with a turnover-based system of rent. And some commentators have described this as letting the genie out of the bottle. And we can certainly expect to see similar rent systems in future CVAs. On the other hand, it should be remembered that if the jurisdiction challenge had been successful, it would have placed limits on the aggressive use of CVAs and shifted compromises elsewhere. Others have emphasised the pragmatic nature of the decision, avoiding insolvency, job losses, and even greater losses for creditors. But it comes at a cost, principally to landlords who feel that they are bearing more than their fair share of the pay. In conclusion, although this root and branch attack failed, there are clear indications that the court will carefully assess cases where certain creditors are unimpaired by the CVA, but nonetheless carry the vote. Thank you for listening.
Good morning. I'm going to now talk about the Regis CBA challenge, which was decided very shortly after New Look. I'm going to go through what the proposal contained, the challenge itself, what was successful, what was not, and what the effects of it were, and possibly where it leaves us. So it was quite different circumstantially to New Look. The proposal was approved in October 2018, and by the time of the hearing of the challenge, the CVA had terminated and the company had gone into administration, which meant there was some limited practical utility in the application. Really, it was all about repayment of the nominees' fees. But for landlords as a whole, I think we can draw some hope from the case, and Zia will hopefully have some time at the end of the presentations to talk about the possible wider positives that come out of the case. The CVA contained the usual provisions preventing creditors from taking action in respect of compromised liabilities, and as in New Look, there were categories of creditors whose debts weren't impaired. They were critical creditors who were determined as being essential for the continued trading of the company and would be paid in accordance with their existing contractual or other liabilities. The compromised creditors, by contrast, stood to receive a dividend of 7 pence in the pound to be funded by 9 quarterly payments by the company, totalling £300,000. The CVA indicated that the alternative to the approval of it was a shut-down administration where the estimated return to creditors was nil. In addition, there was a profit share fund established by the proposal where the company was to pay 20% of the amount by which the aggregate of the net profit for the next 2 years exceeded £250,000 up to a maximum of £200,000, with any surplus to be repaid to the company. So, unsurprisingly, a number of landlords drew the short straw in the proposal and were the compromised creditors, or the bulk of them. There was another category, in addition to categories 2 to 5 of the landlords, at category 1, where the premises that those landlords held leases in respect of were deemed essential and their rights were largely unimpaired. But for categories 2 to 5, there was a cascade of impairments that they suffered. All of them had their arrears claims compromised to get 7% of all determined rent, service charge and insurance arrears. For category 2 landlords, they were to get 75% of rent payable going forward, paid monthly in advance, and in exchange for which they would get a right to terminate the lease on 60 days notice at any time within 90 days of approval of the CVA, or 90 days prior to the 3rd anniversary. In addition, if they were a landlord of multiple premises, they were only entitled to serve 1 notice terminating all of the leases. Category 3 landlords had broadly the same rights, save that their rents were reduced to 50% and their right to terminate was on 60 days notice within 90 days of the effective date of the CVA, or 90 days before each anniversary. Same too for category 4, but their rent went down to 25% and the right to terminate was on not less than 60 days notice at any time before expiry or determination of their leases. And then category 5, the most undesirable premises, went down to nil rent and a right to terminate on at any time on 30 days notice. The calculation of the landlord's votes in respect of future rent was set out as on the screen. So firstly, there was an application of an 85% discount to the contractual rent as the anticipated rent that would be achieved going forward. The assumption was that it would be relet on the basis of the existing leases after a void period of 6 months and with a rent-free period of 6 months. And then on top of that, all claims were subject to a 75% discount. By contrast, there were 2 major creditors who were left unimpaired, 2 of the critical creditors. And the first was Regis Corporation, who was the former ultimate beneficiary of Regis until 2017. In October 2017, there was a share sale of Regis's shares to International Beauty Limited. And in the process of that, prior to that sale, there were a number of transactions that the company undertook to transfer out of its ownership assets into the wider Regis core group, including a number of valuable franchises like the Supercuts business. In the course of the share sale, IBL became the franchisee of a number of those valuable businesses. And after the sale, the company continued to trade with the benefit of those brands. So it continued to trade as the Supercuts brand, for example. After that sale, a dispute arose between IBL and Regis Core, which was settled in 2018. What happened was IBL issued a promissory note for the value of $2.2 million with a maturity date in August 2020. If no default occurred under that promissory note, then what would happen was Regis Core would be entitled to a percentage of net proceeds received by IBL or the company of certain events. Crucially, at the same time, what the company did was to issue a debenture in favour of Regis Core, where it agreed to pay the amounts due by IBL and also granted a fixed and floating charge over all of its assets and undertaking. No consideration was received by the company for the liability to pay the grant of security. The debt of in excess of £1 million owed to Regis Core in the CVA was in respect of that those secured debts, and the debt of £600,000 owed to IBL was said to be in respect of an intercompany liability due and owing in connection with royalty payments, transitional service payments, and payments for stock. So what were the issues? First, there was an issue about whether there was adequate disclosure to the creditors in the CVA proposal. Then, sort of the meat of the challenge, should Regis Core and IBL have been admitted to vote, and was their treatment as critical creditors unfairly prejudicial? Third, there was an issue about claims discounting, and whether the calculation was materially irregular or unfairly prejudicial. Fourth, there were issues about modifications to the leases and whether those modifications were mitigated, like in New Look, by the termination rights or the profit share fund. And last, critically, the nominees' conduct. Had the way they behaved in relation to the proposal been a breach of duty, and if so, what would the consequences be? On non-disclosure, Mr. Justice Zaccaroli reiterated that it would only be a material irregularity if there was a substantial chance that the non-disclosed material would have made a difference to the way the creditors would have voted. And in essence, what Mr. Justice Zaccaroli said about the IBL and the Regis Core transactions is that even if the creditors had known, it wouldn't have made a difference. Firstly, there were serious reasons to doubt whether those claims were good claims to challenge the transactions, unpick them if the company had gone into liquidation or administration. But in any event, in light of the choice facing the creditors, a shutdown administration, there was no real prospect that they would do any better. So it was unlikely that anything other than approval of the CVA would have occurred. On the question of whether a shutdown administration was an appropriate alternative, it was fact specific. What Mr. Justice Zaccaroli said was that the question for him was, however, not to determine whether what would have happened had the CVA not been approved, but whether it was reasonable in the circumstances for the nominees to present shutdown administration as an alternative. And it was a question on which reasonable insolvency experts could disagree. Then the question of how Regis Core and IBL were treated. It was accepted that there was prejudice to the creditors whose claims were impaired, and it was also agreed that that prejudice was unfair unless it could be objectively justified. Very commonly, justification for payment in full of some creditors is that it is necessary to do so because those creditors' ongoing support is critical to the success of the CVA, and they will not provide support unless their debts are paid. For Regis, the contemporary documents made clear that Regis had said that its support was conditional upon its debt not being impaired by the CVA. But there was no express reference in the documents that if its debt were impaired, it would terminate any license agreements or franchise agreements which would render the CVA not viable and lead to an administration. Nonetheless, Mr. Justice Zaccaroli concluded that there was sufficient justification for not impairing its debt. Leaving its debt unimpaired meant that Regis Core retained the right to share in the upside from a future sale, but if there was a default, then its debt would become immediately payable. The consequence of that was that an administration would be inevitable, but if that occurred, then the CVA would be terminated and would have deemed to have never have happened. So all of the creditors would be in the same position. In addition, and critically, its right to enforce its security could not have been affected without Regis Core's agreement. And so practically, it would have been entitled to look to the security for the full amount of debt anyhow. However, the position in relation to IBL was entirely different. The amounts paid to IBL would in fact be paid to Regis Core for the franchise agreements and licenses. But those promoting the CVA failed to take into account, firstly, that IBL was the entity that was obliged to Regis Core. Secondly, IBL was backed by a private equity firm. And thirdly, any reduction in the company's debt burden was of a benefit to the ultimate parent private equity firm. And crucially, the non-impairment of IBL's rights had a very significant impact on the unsecured creditors. IBL was entitled to be paid £600,000 immediately, whereas the funds for all other creditors were only £300,000. So it was unfairly prejudicial to categorise IBL as a critical creditor. In respect of the claims discounting, the position was different to New Look in two critical ways. Firstly, the blanket formula that was applied to all the claims, and that was considered to be inappropriate given there were large variations in the prospects of reletting the premises. A discount of some kind was justified in order to arrive at the estimate of the minimum value. But in Regis, it couldn't be justified because of the prospect of it being an overestimate for some landlords of their loss and an underestimate for others. In addition, the amount of discount was problematic. Some justification has to be offered for the discount that is offered, and there was no evidence in support of that, save that it had been applied in most CVAs in the retail context since 2011. And while Mr. Justice Zaccaroli said that had a bearing on how reasonable the nominee had been in proposing that discount, it was irrelevant to the actual reasonableness of the discount itself. So his conclusion on unfair prejudice on IBL rendered this point not crucial to determine, but it appears he would have considered the claims discounting to have been a material irregularity had it not been determinative. Then on the question of modifications, the arguments to a degree replicated those in New Look. The landlord said that the termination rights and profit share were insufficient mitigation for the impairment to their rights under the leases. And again, it was strictly unnecessary to consider the modifications because of the conclusions on IBL. But firstly, Mr. Justice Zaccaroli rejected the argument that the requirement to exercise the termination rights within 90 days of the effective date was insufficient mitigation, on the basis that the landlords had the option to terminate their leases or accept the modifications, and those were better terms than the alternative, i.e. a shutdown administration. Secondly, he rejected the argument that the landlords, that it was unfair that the landlords were unable to recover their property until 60 days after the effective date, on the same basis that he had in New Look, i.e. absent the CVA, there was no real chance of the landlords getting rent during that period at a better rate. However, some glimmer of hope, he accepted conceptually that a provision in the CVA requiring a landlord of multiple properties to exercise one notice to terminate the leases of all would be unfairly prejudicial, because it is a fetter on the option to terminate each lease, and it removed an essential element of the New Look reasoning, i.e. that it is the quid pro quo for the modifications. But in fact, it didn't arise because Mr. Justice Zaccaroli found that it was effectively varied by a side letter. And last, on the profit share, again, he accepted the landlord's argument that the benefit from this was not a real one, because there were no anticipated profits in the 2-year period for which it was established. Critically, what was different from New Look, where there was an absence of a profit share fund, was that the current equity holder was firstly the impaired creditor, one of the unimpaired creditors, and secondly stood to benefit from the CVA in respect of future profits. Then Mr. Justice Zaccaroli turned to look at the nominee's conduct. In essence, the duty is to take reasonable steps for the nominee to satisfy themselves that the debtor's position is materially what is proposed in the proposal. More is to be expected where there is less time, the company is large, and the CVA is complicated. And that was such a case in Regis. Mr. Williams' conduct fell below the standard because he didn't make any attempt to question the propriety of IBL being paid in full, especially where there were a number of factors which suggested it would be unfair to the compromised creditors. So what was the effect of that? The CVA was revoked, but it had already terminated. On the question of repayment of the nominee's fees, in concept, Mr. Justice Zaccaroli accepted that Section 6 of the Insolvency Act gave the court the power to require repayment of those fees. But there was no form in earlier cases for doing so, and he held that the court wouldn't expect a professional person to be deprived of their fees as a result of a breach of their duty, and seemingly restricted it to cases where the conduct was particularly egregious, for example, fraud or bad faith. In the present case, the nominee services weren't valueless, and while the conduct fell below that of a reasonable nominee, it wasn't an appropriate case to deprive them of their fees. So it very much confirms limitations on the nominees having to repay their fees. Is it a Pyrrhic victory? Well, it seems certainly for these landlords, but for the landlord body as a whole, there is some hope that comes out of the case. It's an indication of the courts carefully scrutinising the treatment of different creditors, particularly where shareholders are unimpaired. And I think Zia will pick up on this in due course. I'll now hand over to Camilla, who'll talk about Virgin Active.
Thanks, Evie. Morning, everybody. Well, I'm going to be talking about the new kid on the block, which is the restructuring plan under Part 26A of the Companies Act, and in particular the recent decision in the Virgin Active restructuring. I'll be looking at what is this plan, how does Part 26A work, then I'll come on to look at Virgin Active, and finally I'll kind of finalise by comparing CVAs with the restructuring plan and asking what's going to happen next. Well, what is a restructuring plan? Well, it's a new restructuring procedural tool that's been introduced by the Corporate and Insolvency Governance Act last year as a new Part 26A to the Companies Act. It is, in a sense, the walked love child of schemes of arrangement under the Companies Act, but it only applies in cases of to companies in financial distress, and it includes this new power of cross-class cram down, which has garnered much interest in the press. Part 26A is broader in jurisdiction terms than Part 1 of the 86 Act and CVAs, insofar as they are capable of being used to bind secured creditors as well as unsecured creditors, and also they can be used to rearrange share capital. An important point for us as property litigators is, as is the case with CVAs, Part 26A does not permit interference with the landlord's property rights. So you can't force a surrender on a landlord, and you can't take away its forfeiture powers. So the procedure applies if you can get over the threshold, but this is a pretty light touch threshold. It's not necessary to show that the company is balance sheet or cash flow insolvent. The threshold conditions are firstly that the company has encountered or is likely to encounter financial difficulties that are affecting or will or may affect its ability to carry on business as a going concern. And secondly, the purpose of the arrangement must be to address those difficulties. The procedure is more complex and convoluted than with CVAs and involves at least 2 upfront court hearings. The process will kick off with an application being made, most probably by the company, and a practice statement letter and explanatory statement will be prepared, the purpose of which is to explain to creditors what the impact of the proposed plan is, in sufficient detail to enable them to know whether it's in their interest to vote on it or not. There will then be what is called a convening hearing before a High Court judge. The judge at that hearing will consider issues such as whether the threshold conditions have been satisfied, whether he or she ought to order a meetings order in order to have a vote on the proposals, and critically, any issues about class composition will be heard at that meeting, at that hearing. There'll then be the various class meetings at which votes will be taken, and finally there will be a sanction hearing again before a High Court judge, which the court will consider whether to sanction the plan, and in particular if the power of cross-class cram down is going to be exercised, the court will need to be satisfied that the conditions have been satisfied. I mean, this can be quite an intense process for all participants. So for example, in Virgin Active, the practice statement letter was sent out sort of mid-March. You then had a 3-day convening hearing at the end of March. Then you had meetings mid-April, and you had a sanction hearing at the beginning of May with a judgment by the 12th of May. And the reason for that was that the evidence showed that Virgin Active was going to run out of money in the week of the 17th of May. So quite an intense process. The court's power to sanction is in section 901F. Essentially, if every class votes by the requisite majority, which is 75% in value of members or creditors voting, then the court will consider at the sanction hearing whether to exercise its discretion to sanction the plan. If the plan is sanctioned by the court, then it becomes binding on all the creditors, the members and the company, similar to CVAs. Now, this is the new power, the cross-class cram down in section 901G. And this applies if at least one of the classes doesn't vote by the requisite majority. In that situation, the court has to ask itself whether the cross-class cram down conditions A and B apply. If they do, then the court can, but is not obliged to exercise its discretion to sanction the plan. Obviously, if the conditions don't apply, then that's an end of the matter and the plan won't be sanctioned. The cross-class cram down conditions. Condition A is called the no worse off test, and this is essentially that if the court has to be satisfied that if the plan were sanctioned, none of the members of the dissenting class would be any worse off than they would be in the event of the relevant alternative. And the relevant alternative is whatever the court considers would be most likely to occur in relation to the company if the plan were not sanctioned. Now, there may be a dispute about that in any case, but it might be liquidation, it might be a pre-pack, it might be a trading administration, or it might even be different restructuring proposals. And condition B is essentially that at least one other interested class has voted in favour by the requisite majority. So moving on to Virgin Active, the sanctioning decision or judgment was given on the 12th of May, and Mr. Justice Snowden sanctioned plans that had been proposed by 3 companies in the Virgin Active group. I'm sure you'll all be aware that Virgin Active run gyms. Their business had been severely impacted by the pandemic because they were dependent on subscription income, which they weren't getting during the lockdown, and obviously they had all of their overheads, including rent and rates to pay, subject to any concessions. And it's an important case because it's the first time that the High Court has been asked to consider sanctioning a plan under the new Part 26A, which had the effect of compromising existing and future claims by landlords under leases. And also it is a striking example of the cross-class cram-down power being exercised against dissenting landlords to effectively achieve a compromise that could not have been effected by way of a CVA. So moving on to the plan creditors, the creditors who were compromised by the plan included the secured creditors under a senior facilities agreement, but they weren't actually, their debt wasn't being written off. They had most of them had signed up to the plan in advance, and they were effectively varying the terms of the lending to be more advantageous to the company. So in that sense, they were compromising. The main impacted group was, as this common theme from today's discussion, was the landlords. And they were divided into classes A to E, and many of them had unpaid rent claims of about 30 million in total, sort of essentially pandemic arrears. All I'll say about the treatment of landlords is you could pretty much cut and paste how, the sort of scheme that one sees in CVA cases into the restructuring plan. So Class A was literally moved on to monthly rents, and Class A was the only class of landlord that had its rent arrears paid. All of the rest of them had their rent arrears compromised for essentially a payment of a dividend, which was calculated at 120% of the estimated administration return. So a 20% uplift on what they would get in administration. And there was a mixed bag of general property creditors who were similarly being compromised. And again, like CVAs, there were 9 categories of excluded creditors who were deemed critical, such as employees and trade creditors, and they weren't compromised under the plan. We could probably talk for 45 minutes about the convening hearing, but I won't. All I'd say that if you would like to know more about what happened at that, then there's a fully reported judgment on it. But essentially, Snowden made a meetings order convening 21 meetings of various classes. That's 7 classes for each company. So essentially each of the landlords was treated as a separate class. So Class A landlords voted separately from Class B landlords, etc. And not surprisingly, the secure creditors and Class A landlords voted overwhelmingly in favour, but the majority was not achieved in relation to the remainder of the landlords and the general property creditors. So there were a considerable number of dissenting classes. The sanction hearing was held in May, and the plan was sanctioned, and Mr. Justice Snowden basically held that the cross-class cram-down conditions were satisfied, firstly because the secure creditors and the Class A landlords had voted in favour, but importantly because the court was satisfied on the evidence that the dissenting classes of creditor would be no worse off in the relevant alternative. And the judge also exercised his discretion to sanction the plans. And there are 2 important features that come out of that. First, and the main point, is that he held that as the dissenting classes of creditor were out of the money in the relevant alternative, and I'll come on to that, their objections to the plan carried no weight. And secondly, in any event, it wasn't unfair for the shareholders to retain their equity, as they had provided substantial new money on market terms, which would rank junior to the senior facilities agreement. It's not all doom and gloom for landlords. The judge went through in some detail the principles that would apply in not only looking at cross-class cram down, but also looking at discretion. I mean, Virgin Active must very much be seen as a decision on its own facts. The planned companies would otherwise have entered a trading administration involving a distressed sale of part of the UK business, and there wasn't really any dispute about that. And the planned company's valuation evidence showed that in administration, the value would break with the secured creditors and the unsecured creditors would be out of the money. Contrast the position under a plan where at least the dissenting credit classes would get at least a 20% uplift on what they would get in administration. And the judge was slightly dismissive of the sort of approach of the landlords, ad hoc group of landlords in that case, who had called factual witness evidence from experts at PwC to kind of criticise various points about the valuation evidence, but hadn't actually produced expert valuation evidence themselves, and also hadn't applied for disclosure as promptly as the judge thought they should have done. And he didn't think the process was unfair. In terms of discretion, there were arguments there that essentially, well, once you've got over cross-class cram down, then it's a fair wind and the court should ordinarily sanction the plan. Well, the judge didn't accept that at all. Satisfaction of cross-class cram down is not enough to get over the discretion threshold, and it wasn't appropriate to read down any kind of limiting principles as to that. And also the judge said that actually the court should be more reluctant, or shouldn't have the usual reluctance to differ from the vote in a case where cram down powers are used such that at least one of the classes hasn't voted in favour. And really the takeaway is the court said that as with scheme cases, the judge must consider all of the relevant factors and circumstances that it would ordinarily take into account when considering whether to sanction a scheme. It is not a rubber stamping exercise. A key point to appreciate about the Virgin Active decision is that it is an out of the money case, and the application of the out of the money principle was critical to its outcome. And the out of the money principle is that it is for the company and the creditors who are in the money to decide, as against a dissenting class who is out of the money, how the value and assets of the company should be divided. Out of the money creditors can even be excluded from taking part in any vote. And of course, in the Virgin Active case, because even the secured creditors wouldn't get a full recovery in administration, all of the unsecured creditors were essentially out of the money. But the position is likely to be very different in the money case. And I understand that the upcoming Ncp challenge is an in the money case, because the court will be much more on its guard to ensure that any restructuring surplus, as it's called, is fairly distributed between in the money creditors. And finally, differences in treatment between unsecured creditors will be justified if there's a good commercial reason for it, such as excluding ongoing trade creditors. But a plan should not discriminate arbitrarily or capriciously between different classes of unsecured creditors, even if they're all equally out of the money. So if you had a case where Class A had voted in favour and there weren't secured creditors and were being used to cram down other groups of landlords who have been treated more prejudicially, then you're much more likely to be in the realms of a successful challenge. But what I would say that if you're going to challenge as a landlord, other than it's important to sort of probably group together with other landlords to do so, to sort of share the pain, is the outcome of any individual case is going to be highly fact sensitive, and valuation evidence is going to be critical, both in respect of the no worse off test and also in determining whether landlords are in or out of the money. And landlords must act quickly to seek necessary disclosure. And it's clear from the judgments that plan companies are expected to cooperate with such requests. And finally, what I would say is that landlords will also need to consider the cost implications, but the rules that apply in relation to plans are slightly different than CVAs in that the usual cost follow the event rule doesn't apply with such rigour in relation to plans. So perhaps slightly more preferable cost treatment for landlords under Part 26A. So just to sort of conclude, going forward, I get asked, is the restructuring plan the new CVA? I think no, I think they're both going to be important tools in their own right, and the choice between them is always going to be bespoke to the company. I suppose the key point is that plans are very expensive and they require upfront expenditure being incurred, but of course they'll provide a company with much more certainty. And of course the use of the cross-class cram down power is going to be very important because that will be a potent tool where landlords' voting power is such that they could otherwise defeat a CVA, and that might prove, so it might be that plans prove popular for companies looking to write off their COVID arrears, so far as that sort of backlog or the cliff edge of those arrears is such as to take them over the threshold they need for a CVA approval. Just finally, the choice is ultimately going to depend, I think, once these procedures are bedded down, and I think Zia is now going to comment more on how she sees that panning out.
Thank you, Camilla and Evie and David. We've covered an awful lot of ground, and I think there's a lot of food for thought there. I know some of you will need to leave now because we're at an hour, but could I just pick up a few points for any of you that can stay? From my point of view, although a number of the challenges failed and the rescue culture remains very strong, I think landlords have made some pretty significant progress in redressing the balance, and that there is still a good amount to play for. In recent years, it's felt as if CVAs are being structured really for the benefit of shareholders and finance creditors, and I must say at the expense of landlords. I have always thought, as some of you will know, having heard me say so quite trenchantly, that courts should be perhaps a bit more robust in saying, if you think this business is viable and you are prepared to invest in it, then put your money where your mouth is, and why should it always be the landlord subsidising? I've also wondered how many of the numerous CVAs have in fact resulted in the business actually continuing. I suspect that many have ultimately collapsed anyway, having traded had the benefit of trading at landlord's expense. So what does the future hold? As I say, I think that there's still a good amount to play for, and I think as many of you will know, there are some large battles already looming. First of all, New Look is being appealed. I know that there are people in the audience who will know a good deal more about the detail of that than I do, so I'll leave it at that. Second, Mr. Young's challenge to the Cafe Nero CVA is proceeding, and I think we can certainly expect to see some guidance there on, for example, voting procedures and changes of circumstances. And third, and I think really importantly, is the Ncp Restructuring Plan, which Camilla has alluded to. That has already had the convening meeting, and the skeletons from that are therefore available. It's due to have a 3-day sanction hearing next week, and that I think promises to be a fairly wide-ranging fight. It is a very different case from Virgin Active, so although some people call it Virgin Active Mark II, it is very, very different. Because I think there is very little secured debt. But despite that, the unsecured creditors, who are therefore in the money creditors because of the lack of secured debt, the proposal is for them to be impaired while equity is left intact. So that feels very different factually to Virgin, and I think it'd be very interesting to see how the court deals with that. It's clear from the skeletons at the convening hearing that an investment group linked to one of the landlords has tabled a bid on terms which they say will give a better outcome. So we'll wait with interest to see what the court makes of that. And then finally, I've seen in the Estates Gazette and the Telegraph that some landlords are considering using their termination rights, and are talking to other operators. So it'll be interesting to see how that pans out too. As far as sort of just summarising the glimmers of hope from the 3 cases we've been looking at, for me, Regis provides a big step actually in the right direction, because there was a recognition in Regis that it is unfair to favour shareholders at the expense of the landlord. Their IBL seems to have given favourable treatment, have been given favourable treatment only because it was a shareholder rather than for any justifiable reason. And the other thing that I think is really important is that it was said that the absence of a profit fund, so that's a fund that the impaired creditors can participate in to share in the future profits of the business, while the absence of such a fund is not automatically unfairly prejudicial, it is something to weigh in the balance when looking at differential treatment. And that links to the point I was making at the beginning about why should it be the landlord subsidising while private equity in many cases coins it in. In New Look, although it didn't succeed, this challenge didn't succeed on the facts, Mr. Justice Zaccaroli did leave the door open, as David said, for unfair prejudice where the CVA has been passed only because of a large swathe of a vote of large swathes of creditors who are unaffected by the CVA, and David looked at the factors that will be in play there. And then, as Evie mentioned, blanket percentage discount of landlords' claims for voting purposes. That blanket discount was justified in New Look, but it was not justified in Regis. So again, there's scope there for the future. I think it will depend on the facts and the evidence. And finally, Virgin Active made it clear that the court will look at whether the dissenting class received a share of the value of the enterprise that is preserved in a way which is proportionate to the compromise it is being asked to make. So I think there is an emerging recognition that if landlords are being asked to take a haircut, then there should be, and if it is being said that the company will trade profitably, then there should be some quid pro quo for the haircut. So the decision seemed, to me at least, to give some modest cause for optimism, and I feel that the balance may be shifting slightly in a more sensible and fairer direction, and that's in no small part due to landlords taking concerted action and looking at the long term rather than their own immediate interests. So although, as Evie said, in Regis the CVA had already come to an end, the landlords who pursued that challenge did the rest of the industry provided some significant benefit to the rest of the industry in articulating and winning on some of the principles that will help them. Now, I know that some of you will need to leave now, and for those of you who do, thank you for coming. If people want to stay on to talk about the questions that have been asked, please do so. I'll ask the other participants to turn on their videos, and just before I've seen the 2 questions, I'll start on them if I may, and then ask the others to pick up. Can I say that in answering the 2 questions, I'm sorry, I'm apparently not allowed to refer you by name, even refer to you by name because of GDPR, even though I obviously know both of you, so please don't take that as any lack of courtesy. I'm just told I'm not allowed to do it. The first question is, can it be expected that a landlord's right to terminate will be an invariable feature of CVAs in the future? I'd be interested to hear what the others think, but my own view is yes, it is part of the quid pro quo. Evie's written a a good article on that which may interest you. But yes, I think it is likely to be a feature. And as I've already said, in Ncp, the landlords are talking about using that right and dealing with alternative operators. Do any of the rest of you want to add anything to that? No.
I think I would probably just add it's almost going to be essential. I wouldn't like to say it would be there in every case, but it's such a fundamental part of the balance that if the rent is being reduced, there's got to be some quid pro quo, almost always. And it's difficult to see what that could be other than including a right to terminate early. So I certainly think it will be there in the future. I'd hate to say invariably, but certainly with a very high degree of frequency.
I think that's right. I mean, right, I think certainly in cases where the contractual rent for the future is being reduced, and obviously if you just had a much more straightforward CVA that just compromised existing rent arrears, then the issue's doesn't arise so much, because if you say, well, you're getting, you know, an uplift in the by dividend payment for your arrears, but certainly if you're varying contractual rent for an ongoing basis, then as David said, it's the sort of essentially the quid pro quo. I think there are all sorts of interesting questions which we won't have time to go into today about what is the nature of that break right and how it operates, particularly with the 54 Act, which I'm not sure any of us have really quite got our heads around. If perhaps it may be that in a future restructuring challenge to a CVA, one might sort of question whether how effective that break right actually is in 54 Act cases. That might potentially be a ground for future cases to undermine the break right being the complete answer, so to speak. But very, very difficult questions.
Thank you. And the second question, to what extent have the fundamentals on privity and sanctity of a contract between two parties been undermined by the group actions of creditors through the CVA process who have no relationship to a specific contract? To what extent is a contract binding in the wider sense, and how should a potential investor be advising as to the security of income from a lease contract? Well, I mean, I think the short answer is that if a CVA is passed, affecting the compromise of claims, then it has undermined the privity and sanctity of the contract pretty fundamentally. Camilla, I know you wanted to say something about this question.
Well, I think that's right, and I think perhaps the more interesting question is how it's going to affect financing, because I was speaking on a panel yesterday with an investor, landlord, who's basically saying, well, you know, he gets called up by foreign investors, and the first thing they want to ask about is, what is this CVA? How does it impact? Because landlords look at, you know, they make their money out of the income that they're guaranteed to get from the asset. If they're not guaranteed to get that income, and it can be unilaterally kind of reduced on an ongoing basis, that's problematic. And I think that's, you know, part of the sort of wider problem is it a sledgehammer to crack a nut, and what impact will it have on the investor market?
So that is actually part of the question that was asked. How should a potential investor be advised as to the security of income from a lease contract? Well, I'm afraid it's pretty precarious if the CVA goes through, and it's quite hard to say to an investor that the income is secure.
Perhaps the other sort of stance on that would be to say, is it actually the process that's the problem, or is it the fundamental insolvency situation of the tenant? Because an investor's, you know, you're never guaranteed to get your money, because your tenant could go bust. So that's always been a feature of the market, and of course that's why people want to maybe, you know, want greater parent guarantees and the like, and rent deposits, and maybe that might become again, but it depends on the market and how strong the landlord's position is and be able to extract those sorts of advantages.
Yes, I mean, I suppose the difference with the CVA is that with other insolvency processes, that they're unpalatable, they're unpleasant for the landlord, but it comes to an end, and then if there is a market, you can relet. but with the CVA, you're kind of dragged through it for a couple of years. That's sometimes to no effect because the company will go anyway. So I hope that answers those questions. If the people that have asked them would like to add anything or any further questions, clarification, do please email us, and we'll do our best to help with that. Thank you all very much for coming and for listening, particularly on this beautiful day. And we'll sign off now. Thank you. Bye bye.